Hi, I'm Maria Luisa Noel Ballesteros. First of all, on behalf of my group mates, we would like to thank Mr. Andrew Wang for giving us this opportunity to study and analyze the case about the risk of auditors in litigation. Our topic is Deloitte's 2005 settlement of 200.
My name is Ai Fang. I'm going to talk about the introduction. My friend Tim is going to talk about case background. My friend Rubin will discuss the case analysis. And Maureen is going to talk about ruling from the court. And the largest is going to talk about the recommendation and conclusion. As well as the ground, why Sampo filed a complaint against the Deloitte seeking financial compensation for their negligence, misrepresentation, and supporting. The paper shows the relevant issue in auditors such as mistakes, misrepresentation made by defendants that result to advice, judgment, and the awarding of damages. Finally, recommendations and possible improvement are given to prevent the repetition of the same litigation in the future. Now, Tim is going to talk about the case background.
Hi, my name is Tim Cook, and I'll be running through the background to this case. So in 2002, Sompo, who were a Japanese insurance and reinsurance company, brought a lawsuit against Deloitte, who of course are the top US accounting firm, or one of. Deloitte at the time were the auditors for Fortress Reinsurance, and Fortress Reinsurance was a collective reinsurance pool formed by Carolina Reinsurance, AOI, and Sompo Reinsurance, who were both Japanese insurance companies. What they did together is they specialized in aviation insurance. And following the attacks, 9/11 attacks in 2001, these companies had to collectively share the risk involved in covering the 4 planes that were lost in the attack. And so what Sompo claim against Deloitte is negligent misrepresentation, aiding and abetting Fortress's breach of fiduciary duties, fraud, and unfair or deceptive acts. What they do is they cite a failure to be told of the huge hidden liabilities that Fortress had incurred on their behalf, as well as Deloitte, as the auditors had inaccurately claimed Fortress had obtained insurance to cover the losses on their policies. In fact, they had actually been relying heavily on financial reinsurance. So what this case highlights or looks to examine is whether Deloitte can be held accountable for the misconduct of Fortress, or whether, as an auditor, they should have known. Deloitte, as will be later explained, claim that they did not know that Fortress had been conducting these acts, and also whether the charge of aiding and abetting can be held against Deloitte if it's found that they didn't have any knowledge of this behaviour. So this is something my teammates will examine in more depth now. Thank you.
Thank you, Tim, for discussing the case background. So now I'm going to discuss the part 3 of our paper, which is the rulings from the court in the case Deloitte's 2005 settlement of $250 million regarding its audit of insurance company Fortress Reinsurance. So on this case, the plaintiff is the Sompo, which made an amendment to its claim seeking editorial changes to refine certain factual allegations and to expand its aiding and abetting claim. So the claim refers to the adoption of Section 876, Part B of Restatement of Torts 1979, for which the North Carolina courts concluded the following: restatement of torts was not effective law in North Carolina unless a specific section was adopted. This is cited by the cases of Marcus Brothers Textile Incorporated versus PricewaterhouseCoopers on the year 1999. So in this case, the plaintiff is Marcus Brothers Textile, which is based in New York, this company is a textile that buys unfinished wooden products, and then there is an independent contractor that will finish the product, and then the Marcus brothers will sell it to apparel manufacturers or retailers of fabrics for home sewing. So, and then the defendant on this case is the PricewaterhouseCoopers, which is an independent accounting firm in North Carolina, and then hired by Peace Goods Company to do the audit in their company's year-end financial statements and other audit services from year 1986 to 1993. The case that we provided in our paper on the part of the court rulings highlights how difficult it is to separate aiding and abetting from a direct fraud claim if Deloitte showed no knowledge or intent to do so. Without application of aiding and abetting, under this condition, the claims against Deloitte is redundant. So it is reported that Deloitte paid in the region of $250 million to settle litigation. My friend Ruben will discuss the part 4 of our paper, which is the case analysis.
Thank you, Maria, for the wonderful explanation. Now, I'm going to explain about case analysis. The auditing firm should not suffer from the fraud of your client. The special Supreme Court judge, Bin F. Tenley, summarized that if a professional such as accountant and lawyer could be held liable for fraud when the client used their service to defraud a third party without the professional intent to participate in the fraud, the cost of such service could be prohibited to all but the accused. Fortes reclaimed that they sent correspondence to Deloitte. Tenley, a superior court judge, suggests a provision for expenses may be created by auditing professional or investigating in how the client was using their service or financed by the insurer. However, Deloitte claimed that they prepare financial statement for the use of management and member company only. Here, there was a confusion between Deloitte and the auditing Fortes Re. Here, Deloitte agreed that they has made the financial statement for the use of management and a member company only. What Fortes reclaimed that is used for general purpose auditing. Thank you. Now I'd like to call my friend Rajesh to explain and conclude about this case. Thank you
for explaining the case analysis. Now moving on with the recommendations. As you can see, I've written that audit companies must carefully organize those terms and conditions, and auditors who will be responsible for doing auditing must go thoroughly for those terms and conditions. And since audit companies can manage their exposure to negligence claim in several ways, they can just simply do those by being aware of the duties and strictly following the codes of conduct. Another way to eliminate liability is through disclaimer of liability. Due to the Bannerman case, a disclaimer of liability to third parties was started in the wording of audit report. Disclaimer may not completely remove liability for third parties, but reduce court ability to accept liability for the third parties. There is also another way, which is using liability limitation agreements. Since 2008, the company law has allowed auditor to use liability limitation agreement to reduce the customer's risk of litigations. LLAs are incorporated into a compromise that impose a limit on amount of compensations that auditor can seek. So the conclusion, our paper encapsulates the debate around auditing liability. There is a growing sense among professional service community that risks involved in providing auditor for larger listed business is becoming too prohibitive. The example above is just one of the very few large cases that have been involved in huge litigation settlements from audit firm in the last decades. We provide recommendations and possible improvements on how to reduce having a liability for auditors, and as well to prevent this kind of litigation in the future. Other accounting researchers might want to use these suggestions into their discussions of importance of auditors' professional liability and the impact of this case to the future financial report users. Thank you.